I'd like to give the stage to you to set up, the framework of this discussion, because I think that your American perspective gives a little bit of the overview of what we are going through, what this country is going through, and let's talk a little bit about, the international. What is the impact about the perspective and the perception that the international world has on American politics? The stage is yours, please. Go ahead.
Professor Tribe, welcome. It's great to talk to the man I consider to be the leading constitutional authority in the United States. Professor, you taught many of the people who will be watching this impeachment and in fact leading it, starting with Congressman Jamie Raskin. How do you think this trial should go in terms of just having one count? I think it might have been better to have three counts. One about the riot itself, one about the Georgia election tampering, and the third about the Justice Department meddling.
Well, I think the decision to have one count, insurrection and incitement to insurrection, which is wrapped into the insurrection, was a quite reasonable one, partly because all of the rest is part and parcel of a course of conduct, which is going to be elaborately demonstrated on the Senate floor by Representative Raskin and the 8 other House managers. It's not as though the threat to get Raffensperger, the Secretary of State of Georgia, prosecuted, and the attempt to manipulate the Department of Justice were independent acts. They were all part and parcel of an attack on the government of the United States. We deliberately, I say we, but the House managers deliberately did not call it treason, but that's very much what it was. It's a lot like the trial in 1862 of a federal judge in Tennessee, Judge Humphreys, who was charged basically with insurrection against the United States, inciting an attempt to rebel. It was not called treason, but that's what it was. And as in this case, the judge who was accused of that refused to show up at the trial, even though he was invited. And one of the reasons he was ultimately convicted was the thought that anyone who is accused of a course of conduct that involves toppling the American government, which is the most serious imaginable charge, who is innocent in some way, would obviously want to come and explain himself. That's what this president has not done. He's invoked a technical legal argument that I think is fallacious, that somehow because he's no longer president, he can't be convicted and barred from holding future office. But he's declined to defend himself on the merits, except he has lawyers saying he only used the word fight a few times. He didn't mean it literally. So I'm quite satisfied with a single impeachment count.
The reason I ask is, since this is really a political trial, not just a criminal trial in the sense that it was in a courthouse and would be conducted somewhat differently, wouldn't it have been easier to force the senators, the Republican senators, to have to vote on something that they can't fuzz up with a First Amendment defense? I mean, there's certainly no First Amendment defense about meddling with Georgia.
Well, these people use the First Amendment whenever words are involved. All he did was talk to Raffensperger. They would make the point that all he has done is use words. It's speech. I wouldn't underestimate their ability to stretch and twist and abuse the First Amendment. I don't think, speaking of the politics of the thing, that they have the slightest bit of shame about using the First Amendment, even when it doesn't apply. The politics, I think, is focused on the fact that they are trying to avoid having to vote on the merits, but that's not going to be possible. Because today, the way this trial is structured, today they're going to be voting on whether the technical defense, the defense that he's no longer president, therefore you can't do anything to him, in the Senate, that's going to be voted down. It's going to be voted down by a vote of at least 55 to 45, maybe 57, 58. At that point, the rest of the trial will be on the merits. And in the end, those people who vote to acquit him will perhaps use the excuse that they were not really persuaded that the trial was constitutional, but everyone will know better. They will know that they're fundamentally afraid of the political power of Trump's base and of the database of information that he has, in addition to the people that he can threaten with primary opponents.
Do you think that it would be helpful to the case, or just muddle it up, if the House were to call witnesses?
Well, there will be a separate vote on whether witnesses can be called. And many Democrats, including, I think, some of the managers, are in favor of at least having the option of calling witnesses, depending on what the trial looks like at that point. I think it's important that that option be open, but whether in the end it will be the right tactical choice is one that I'm really very happy to leave to Jamie Raskin and his colleagues on the House managers team. As you point out, he was a student of mine, very brilliant student. He then became a professor of constitutional law in his own right. He is the leading constitutional scholar in all of Congress. And he is, for that reason, someone that Nancy Pelosi relied heavily on even in the first impeachment, although another student of mine, Adam Schiff, did a wonderful job leading that group of House managers, because that one emerged from the international national security context.
I think that's the perfect segue to bring up a third student of yours. You know who that's going to be.
Ted Cruz, no doubt, right? Or Barack Obama. Let me guess.
Ted Cruz. So the question is, would you favor calling witnesses like Ted Cruz or Lindsey Graham to see if they conspired with Trump?
Not really. I mean, there may be more there than I know about. I'm not sort of involved in the day-to-day tactics of all this. But I think on the whole, giving people like Cruz a platform to pontificate and continue distorting the truth is not helpful, especially given the desire to get this trial over with in a couple of weeks, rather than having it stretch on and on the way Andrew Johnson's trial did in the wake of after the Civil War and the assassination of Lincoln.
Mm-hmm. Professor Wright, I would like to go a little bit to see the broader perspective of what is happening here from a foreigner point of view. Do you agree that we all see that there is a lot of confusion about how the Constitution can be interpreted, if and whether President Trump can be indicted, if he can be impeached? What are the lessons that you think the world is taking, and what are the lessons that you think the American politicians and the American political system is receiving through this process and through this confusion and through these all counter arguments of whether or not the former president Trump, can be impeached?
Well, first of all, there is no question that he can be impeached, in the sense that an impeachment is simply a charge brought by the House of Representatives. And the House of Representatives in the past, for example, in the case of a former Secretary of War, Belknap, has actually impeached people who have resigned their office in order to run away from impeachment. But he didn't run away. He remained the president. He was impeached on the 13th of January, a week before his term ended. So the question is not, can you impeach him? The question is, can the Senate, in its sole power to try an impeachment, continue to try him when it no longer can use the remedy of removing him? You can't remove somebody who's no longer there. And the confusion about that is the result of simply not paying attention closely enough to either the text or the purposes of the American Constitution. The text in Article 1 makes it clear that removal is only one of two remedies. It's sort of the minimum possible sentence. You have to remove someone who is convicted of high crimes and misdemeanors. But the alternative one is the one that still applies here, and that is permanently disqualifying the person who is no longer in office from ever again holding federal office. In fact, the way the American Constitution works, the only way you can ever apply that remedy, and that remedy was very important to the framers. They knew there were certain people who were charismatic demagogues and who could rile up a mob and take over the government and destroy democracy. The only way you can ever use that remedy is to use it against someone who's no longer in office, because you can only vote on whether to permanently disqualify after you have convicted and removed. And once the person is convicted and removed, it's no longer in office. So it's really a confusion that I hope that the House managers will be able today to clear up. Nonetheless, the American Constitution remains a subject of considerable complexity. Otherwise, I couldn't have spent 50 years studying and teaching about it. I guess I'm in some ways glad that it isn't open and shut and very simple. In fact, there's a cartoon I saw recently in the New Yorker magazine, which shows people with wigs. They look like they're writing the Constitution. And one of them says, why don't we have a good time and make this document a little hard to interpret? And they sure did. That is, but then any constitution for a massive republic, which tries in a compact way to lay out the blueprint and enumerate some, not all of the rights people have, is bound to lead to endless complexity and controversy. That gives people like me something to spend their careers on, and no wonder it confuses foreign citizens and journalists and correspondents.
Professor, to give Thanos the international nod, would you talk about how impeachment evolved in Great Britain and it was understood by the founding fathers?
Well, basically, when the framers were writing the Constitution, they looked at the situation in Great Britain where you can't impeach and remove someone who wears the crown. You could only impeach high officials other than the king or the queen, but you could impeach officials long after they held office. The most famous impeachment that was going on in Parliament at the time that the founders were drafting our Constitution in 1787 in Philadelphia was the impeachment of the former governor of India, Warren Hastings. And he was out of office by the time he was impeached. Impeachment was used in England and in most of the colonies, not only as a way to remove people, but as a way, that is to remove them from current office, but as a way of basically removing them from the political stage. It was a substitute for assassination. Benjamin Franklin made it clear that the reason we needed the impeachment power is that we were a little too civilized to assassinate our leaders. But the point is to get rid of them permanently. And of the judges who have been impeached and convicted, 2 were permanently barred from ever again holding federal office. One more vote and Andrew Johnson would have been barred from ever again holding federal office. That's the real issue here, not whether to remove Donald Trump to Mar-a-Lago, where he happily spends his time, much the way he did while he was president, by the way, but to get rid of him from the American political stage. And the only way to do that is to absolutely guarantee that he can't raise money on the claim that he's running for office again, and to make it impossible for him ever to return with whatever mob he pulls together.
Now, one of the key principles of American democracy is that votes are public and recorded. But if this were a secret ballot in the Senate, how different do you think the outcome might be?
Well, it might be very different, because when you talk privately to senators who are afraid of voting to convict because they are afraid that the people over whom Donald Trump holds sway in their states would hold it against them, many of those people believe that he is an existential danger and would like to see him gone. Some of them even for quite selfish reasons. I mean, people like, like Ted Cruz, to name an example, who fancy themselves running for president in 2024, don't want to have a primary opponent named Donald John Trump. They would kind of like to see him off the stage, but they're afraid. So if it were a secret ballot, which under the rules of the Senate it cannot be, things might be very different. Whether they would be as different as some people imagine, I'm not sure, because after all, we did have a secret ballot in the House of Representatives on the question of what should be done with Marjorie Taylor Greene, the crazy QAnon lady who managed to get elected to Congress, whether she should be censured. And although a lot of Republicans voted to censure her, many didn't. And with respect to Liz Cheney, who stood up for principle and said that she thought Donald Trump was the most dangerous and lawless president we've ever had, even though she was not stripped of her position in the Republican leadership, the secret ballot didn't prevent a very large number of Republicans from nonetheless voting against her. And so I'm not sure what would happen in a secret ballot, but I wouldn't favor a secret ballot because it's important to hold the Senate and individual senators accountable here. It's not just Donald Trump who's on trial, it's the Senate of the United States. And from a foreign perspective, it's the United States of America that's on trial. That is, if a country that purports to be a democracy tolerates a rampaging, pathologically lying, lawless president for 4 years, then votes him out of office, but refuses to hold him fully accountable by convicting him, then we are not quite the example for the world that we want to be. That's why I think it's especially important for our position of global leadership that we conduct this trial and that we do our best to have as many votes as possible to disqualify this man from ever again holding office in the United States.
And what's next if there is the acquittal that many expect it will be?
Well, what's next in what respect?
In terms of the American politics, in terms of the political system, in terms of the image of the United States to the rest of the world, in terms of the effectiveness and the efficiency of the whole process, because what we see here as outsiders of the system, as foreign correspondents, foreign commentators, foreign analysts, is that there is some confusion on and counter arguments, as I mentioned before. And after all of that, if this process ended up in the acquittal of former President Trump, what this whole thing would mean for the political history and for what's next.
Yeah, if he's acquitted, how does this look to the rest of the world?
Well, it will look terrible. It will look as though we can't get our house in order. But the public message to the entire world is going to be affected not just by the fact of the acquittal, but by the actual vote. I mean, there probably will be a bipartisan majority to convict and disqualify this man. It won't be enough, in all likelihood, to meet the requirement of 2/3 of the senators who are present and voting. But it will be a distinct majority, and it will be bipartisan, and that will be an important signal to the world. It will also be a signal, people will be reminded, that Donald Trump was rejected by an overwhelming majority of the American people in the election. He was rejected by a majority that was at least 7 or 8 million votes greater than the number that voted for him. He was rejected by our bizarre electoral college system, by a majority that he in 2016 described as a landslide, overwhelming. And people will look to the Biden administration, which has rejoined the Paris Accords, which is taking a serious leadership role on matters of climate. We will play a leadership role in this global pandemic. We will recover from our economic catastrophe that was exacerbated by President Trump's mishandling of the coronavirus 19. People will look at all of that, and the example of American leadership will not be determined entirely by the fact that we have a somewhat clunky political system designed in the 18th century, which doesn't work quite as well as we would like. That will be true, but we have other flaws in our history. We have overcome them, and we will survive this as well. And our ability to emerge from the deep hole that this tyrannical leader dug will itself be a beacon to the world. So I don't think that America will be discarded as no longer worth following or paying attention to, although people will understand that our system is deeply flawed.
How much damage did Trump do to the international rule of law, and how much does the impeachment and Joe Biden's different view of the rule of law do to the world?
Well, I think he did a lot of damage, because the idea that no one is above the law was really challenged by this guy. And yet, courts repeatedly rejected his claim that he won when he didn't. And there is likelihood, despite the Senate acquittal, that a new Justice Department led by another former student of mine, the marvelous Merrick Garland, who I think will be confirmed as the next Attorney General, may decide to bring criminal charges against Donald Trump. That is, he may be prosecuted for insurrection, for rebellion, for sedition. He will certainly, I think, be prosecuted by state prosecutors. The odds are pretty good that the district attorney of Fulton County, where he illegally twisted the arm of Raffensperger, the Secretary of State of Georgia, in order to try to flip the result in Georgia and make it look like he won that state. Good chance that he will be prosecuted in the state of Georgia. Good chance that he'll be prosecuted by the Manhattan District Attorney. So America will look like a country that in the long run does enforce the rule of law and does make sure that no one is above the law. And in a sense, the fact that we will have dodged the horrible bullet aimed at the heart of our country by this tyrant, despite the fact that he wounded us, the fact that we will have dodged that bullet and learned some lessons about tyranny will, I think, tell the whole world that we are stronger for having survived this encounter with potential dictatorship.
What do you think of Trump's legal team?
Mediocre at best. I mean, the legal team consists of one guy who kept telling Bill Cosby that he shouldn't be prosecuted and wouldn't be prosecuted for his serial sexual abuse, and we know how that turned out. And another guy who told Jeffrey Epstein that he was fine and would not be prosecuted, and we know how that turned out. This is not the A team, not the B team, maybe the Z team. But we'll see. You know, they will have their chance to make their arguments. Certainly, the briefs that they have filed so far are not impressive. Let me put it that way.
Nancy, you have a question.
Yes, I do. Excuse me. Yesterday, it appeared that New York State had to drop its charges against Paul Manafort because of his, quote, pardon from Trump.
Right.
We don't know. I mean, I've never heard of a silent pardon before, but apparently it exists. So my question is, does it exist? Could Trump have given himself a silent pardon? And in that case, would the states of New York and Georgia or any other subsequent states have to drop their charges as well? And
several answers, Nancy. First of all, no pardon, silent or loud, can eliminate state charges. State prosecutions are not affected by the presidential pardon power. It was only the prosecution in New York that was dropped because of New York's special law that says that we will voluntarily give effect in our state courts to a federal pardon. It was a complicated situation which doesn't exist in Georgia or most other states. As to your question of whether the president can pardon himself silently or otherwise, I've argued, and most scholars have argued, that a president cannot grant himself a pardon. That's not within the pardon power. And as to whether pardons have to be public or can be completely secret until finally pulled out to defend against a charge when it is brought, that's a question that's never been answered in American constitutional law. I would argue that because the Supreme Court has said, and because the history of our Constitution suggests, that a pardon is ineffectual unless it is publicly proclaimed and publicly accepted, that the idea of a silent pardon, a secret pardon, one that is hidden in the bottom drawer of the resolute desk in the president's Oval Office, that's just a fantasy. It makes a nice story. I'm sure that there will be dozens, maybe hundreds of novels written based on the bizarre 4 years that we have lived through. And there will be plenty of time both for fiction and nonfiction.
Jonathan, please go ahead to ask your question.
Yes, my question relates to Section 3 of the 14th Amendment, which for listeners would prohibit any office holder who has taken an oath to uphold the Constitution, who has given aid or comfort to an insurrection, from taking any further office that would involve an oath to uphold the Constitution. It would seem to me that giving comfort to an insurrection is a easier standard to meet than stimulating an insurrection. And moreover, it would seem that it could be achieved by a piece of legislation defining objective acts that have taken place as violating it, and it would reinforce the impeachment process, and it wouldn't spring up into the future until someone who would be seeking office would be barred by a constituent of that office holder or an opponent. And therefore, it would not only encompass Trump, but also his supporters. And it would define objectively acts that wouldn't focus on the persona of Trump, but on the insurrection.
Yes, well, I certainly have spent a good bit of time studying Section 3 of the 14th Amendment. And you may know that the article of impeachment right near the beginning refers to Section 3 of the 14th Amendment and its prohibition on future office holding by anyone who engages in insurrection or rebellion against the United States. The difficulty with relying on Section 3 of the 14th Amendment as a freestanding matter, that is, not as part of an impeachment article or as part of some other legal proceeding, but simply on its own, is our ban on bills of attainder. That is, it would not be possible, in my view, though there are some scholars who think otherwise, it would not, in my view, be possible for Congress by mere legislation, even bicameral legislation, even legislation signed by the President of the United States, to declare that a certain list of persons, including but not limited to Donald J. Trump, have committed insurrection or rebellion or gave aid or comfort to the enemies of the United States. And by the way, the reference to the enemies of the United States in Section 3 may or may not include a domestic insurrectionary group. It may be a reference to only foreign enemies. Either way, the idea of objectively defining this as a rebellion or an insurrection and setting up criteria for deciding who is guilty, that idea is being pursued in the Congress. If the president is acquitted, there will be legislation introduced. I'm quite certain. I've helped people draft it. Legislation introduced pursuant to Section 5 of the 14th Amendment, which is the section that gives Congress the power to enforce everything in the 14th Amendment. There'll be legislation introduced pursuant to Section 5 to set up a fair judicial procedure for deciding who should be permanently disqualified under Section 3. And as Jonathan points out, it may well be that there doesn't need to be an initial determination, but rather that criteria are established that will be used if and when somebody who took an oath to uphold the Constitution and nonetheless was involved in this particular insurrection tries to run for public office, state or federal. By the way, both are included here, state or federal. When that person runs for office, there will be an opponent who invokes this legislation passed under Section 5 to enforce Section 3 against the individual. And then there will be a determination, was that individual guilty of being an insurrectionist? It's a long and complicated and convoluted answer, but it is unfortunately a kind of convoluted process.
Pablo Pardo, please go ahead to ask your question.
Hi, can you hear me?
Yes, absolutely.
Okay, perfect. Well, thank you very much for your time. I'm actually been talking on and off with my newsroom in Madrid, so perhaps I've missed something. But I would like to ask you, Professor, something about, let's say, the consequences of this process, or what do you think are the consequences for the public opinion? Because, I mean, I'm afraid that, I mean, the American public is starting to see impeachment as a purely political thing. And to some extent, there's the risk of looking at it as something like particularly irrelevant, let's say. I mean, President Trump has been impeached twice. As long as the party is with him, there's no problem for him at all. So in the future, another president can say, well, I don't really care about impeachment. This is a pure formality, and I can keep on stay in the White House, run for president again. So this political component, how do you think it is going to play in the future? Thank you very much.
Well, Pablo, I very much share your worry. I wrote a book with a colleague of mine named Joshua Matz a couple of years ago called To End a Presidency, The Power of Impeachment. We talked in that book about the danger of impeachment becoming irrelevant if it is invoked in trivial ways, the way it was against President Clinton, if it becomes simply another thing that you do for political reasons, and if it is not reserved to really grave instances of abuse of power. In the case of Donald Trump, despite my reluctance, I favored the use of the impeachment power because he was abusing his power grotesquely, even when he was trying to extort President Zelensky of the Ukraine in order to get the appearance of an investigation against his then primary rival, Joe Biden. And yet, as we saw, the Senate, with the sole exception of one senator, Mitt Romney, acquitted him. Now, if the president, who is obviously, and the evidence is going to make it transparently and painfully obvious, obviously the primary source of a murderous attack on the center of American government is able to avoid the consequences of impeachment because he committed his offense too close to the end of his term for there to be an effective Senate trial, even though Mitch McConnell could have made a Senate trial possible if he had called the Senate back. But if you can get away with even that, the lesson may be to create what the historian Timothy Snyder of Yale calls the January exception. It's a very dangerous exception. I think you will hear the House managers in the Senate trial referring to it. It's sort of an exception that says to a president, if you commit your offenses, including offenses designed to keep you in office permanently, close enough to the end of your term, no power on earth can overcome what you're doing. That is a lesson that says the American Republic may be on its last legs if we don't get past that. And so the lesson is going to be very frightening. And that's one of the arguments that I believe the House managers will make to the Republicans, saying, you may be fearful of Donald Trump and the way he can rile up your voters and your funders against you. But if you care at all about the preservation of this republic, you cannot afford to create a January exception. The vote tonight on whether the Senate has the power to try this man because he's no longer the president of the United States will be strictly a vote on whether there should be a January exception. But even if, as I expect, the Senate will hold that it does have the authority, notwithstanding the fact that the president ran out the clock, to put him on trial and convict him, if it in the end doesn't convict him, that will be a kind of de facto January exception that will be dangerous, not quite as dangerous as one that's formal and institutionalized, but dangerous nonetheless. And that's one reason why I refuse to give up hope that in fact he may be convicted. That's something we'll have to see.
Professor Tribe, I think we can conclude our conversation because it is already 11:37 and I feel that we're running out of time, of your time. And I would like to thank also Allan Dodds Frank for his presence here. Professor Tribe, we thank you so much for your time, and we need your promise that you will be back to a briefing with us once we know what's the whole process outcome.
I'd be delighted.
The future of the American politics.
Well, thank you, Thanos, and thank you, Allan, for joining us, and
Thank you, an honor.
those who asked questions.
Thank you, Professor Tribe.